So are land grabs the only resort left for land-starved South Africans after Parliament yesterday failed to pass the 18th Amendment of the Constitution that would have paved the way for a radical shift in land policy? In the debate that preceded that vote yesterday, EFF leader Julius Malema urged South Africans to take back land, quote, by any means necessary, and accused the ANC of selling out to maintain the status quo. So the author of Land Matters, South Africa's Failed Land Reforms and the Way Forward, advocate Tembeka Ngcukaitobi, joins us now to reflect on what happened in Parliament and perhaps what is the way forward. Advocate Ngcukaitobi, it's great to have you with us on the program this morning. Let me perhaps begin by asking you this. Did you see yesterday's vote in Parliament as some sort of a surprise, the outcome of that vote?
No, it was not a surprise. Perhaps it was even predictable.
Okay.
The ANC knew that it didn't have the support of the EFF, nor did it have the support of the DA, which were the only political parties that could have helped it to pass the required threshold, whether it is a two-thirds majority or whether it is a supermajority of 75%. It always knew it had no support of the main political parties in Parliament. And so when it pushed ahead with its amendment, it must have foreseen that the amendment would be futile.
I mean, some people were talking about the EFF's vote being somewhat of a surprise because the party itself was the one that brought up the issue of an amendment to the Constitution. So it's arguing in its current state, it's not supporting the bill. It wants something a lot more radical.
Yes, I mean, even the EFF vote was predictable. If we look historically at historically in the sense of the last 4 years, and not historically in the sense of the last 400 years, which is what we're trying to resolve. It is the EFF that introduced the motion in Parliament that there should be an amendment. At that stage, the amendment was a relatively modest one in comparison to what we currently have. It was simply an amendment to Section 25 to enable so-called expropriation without compensation. The positions over time have evolved. The current position of the EFF, which was debated yesterday, was full-scale nationalization of land, state ownership of land, which is radically different from the motion that was introduced. On the other hand, although the ANC introduced the own resolution in 2017, it did not, in fact, introduce any motion in Parliament. It reacted to a motion introduced by the EFF, and then it put its own qualifications. So from the beginning, it was always known that these are parallel, although they overlap, but they are substantially parallel motions. The EFF wants different things to the ANC. Yeah. The EFF always wanted every expropriated piece of land to be without compensation. The ANC wanted specific pieces of land to be without compensation. The ANC never wanted state custodianship. The EFF always wanted state custodianship. So even there wasn't any surprises at all. I mean, I think for me the real question is that this was always a misguided amendment. The ANC always knew that it did not need an amendment for land reform. Yeah. It always knew it had the tools in its disposal for land reform. Yeah,
and in fact, when you talk about it not being a surprise, that vote in Parliament yesterday, perhaps the ANC's comments in the run-up to that vote does allude to that, because it said, you know, even if the bill does fail to pass in Parliament, there is existing policy that does enable it to deal with the land question. So I suppose the question is, if there is this existing policy, why does it seem there's been no political will to deal with the issue of land reform in our country, and perhaps more specifically the issue around historical land that were taken from people, for example, under the Group Areas Act, to name just one issue. If the policy is there, why have we not enacted it to date?
Well, Michelle, isn't this the point? I mean, this is really the heart of the point. Why did we spend the last 4 years on a policy that we knew for sure would never pass, but also on a policy that we knew was unnecessary because the legal instruments, the legal architecture is available, and the ANC was always aware of this. And this is why I actually think that this has really been about politicking. It's really about resolving internal disputes inside the ANC and an attempt at outflanking its external opponents. We go back to where we started, which is what is the point of Section 25 of the Constitution. Section 25, contrary to popular belief, does not entrench existing property rights. It transforms existing property rights in at least three distinct respects. Firstly, it calls for redistribution of land. Secondly, it calls for restitution of land. Thirdly, it does not entitle a person from whom the land has been taken to market-based compensation, but rather to just an equitable compensation. Those are the three elements to Section 25, which the ANC should translate into legislation, into policy, and into executive action.
I mean, the three issues that you've just outlined, it addresses the pains of the land question in our country in so many ways, doesn't it? It's still difficult to understand, at least on the face of the three issues that you've just outlined, insofar as Section 25 of the Constitution is concerned. It's difficult to think that it doesn't have the support in Parliament.
Yes, in a sense, I mean, the defeat of the amendment might itself be a signal to a shift back to constitutionalism, as opposed to attacking the Constitution for the failures of the state. So it might be that, in a sense, the unspoken truth is that we are now shifting back to constitutionalism. And that's really been my concern, that there is a radical departure from the principles of the rule of law and the principles of constitutionalism. So take one issue where there has been a glaring failure by the government. Take the issue of the payment in the event of expropriation, which is just an equitable versus market-based compensation. Now, the ANC pushed through a constitutional clause in the early 90s during the negotiations at CODESA and at the Constitutional Assembly against resistance from the National Party, whether or not land would be compensated at full market value or below market value or at just an equitable compensation. It got a stunning victory that land would not be compensable at full market value, but at just an equitable compensation. But you know what happened, Michelle? In 1997, a year after the ANC pushed through the Constitution, it amended state policy so that every expropriated landowner is entitled to full market value. It passed a white paper. So what we've had state policy that is inconsistent with the Constitution. That is not to blame the Constitution. The Constitution is a much more radical, if you like, even revolutionary document. But it's been betrayed by state policy.
I mean, if you take, for example, the issue of, just one example in our country, the issue of District 6 in Cape Town. Full market value now as compensation in an area like that?
No, there is no reason for full market value. Let's look at two different aspects to so-called full market value. The one is, how much do you pay to an expropriated landowner who inherited or acquired land under apartheid or under colonialism? So we can call that white people. And the second part of it is, how much do you pay to a person who is trying to get back the land but cannot get the land, but therefore they should be paid alternative compensation? So for those people who are claiming the land back, but they cannot get it, let us assume you wanted to claim your land, but now in a place where you were initially dispossessed, they've built the Gautrain, so they cannot give you the land. How much should be given to you? Now, in those circumstances, what I have argued, certainly in my books, what I have argued is that those people who are resolving historical claims should be entitled to full market value. So black people who were dispossessed at District 6 and they cannot get full restitution, they should get market-related compensation. But if you are a person who is losing land, but you inherited it from apartheid and colonialism, did not pay any market value when you took it, in fact paid no compensation, and had black people contributing to the productivity of the land, in those circumstances, below market value is justifiable. And that's why we've always needed a spectrum. We cannot have a one-size-fits-all. We've always needed a spectrum on the debate. We've always needed a bit of nuance. We've always needed a bit of flexibility on the debate. So in your example, a District 6 land claimant, so someone who lost the land in 1967, I would say they are entitled to full market value. But a white person who is losing land today because it is going for wider redistributive purposes should get below market value. That's how justice works.
And is there that nuance that our legislation, or at least this amendment even, that failed in Parliament yesterday, did it have that kind of nuance?
No, the amendment was a blunt instrument. It had no nuance whatsoever. The amendment firstly introduced in a very vague and imprecise formula, which is probably incapable of implementation. It introduced the idea of nil compensation. And the second part of the problem with the amendment was that it introduced the idea of state custodianship, which must be achieved over time. But it never explained what is state custodianship, what is over time, what are the factors to be taken into account. So it was always a recipe that would make it impossible for implementation. But on the other hand, the alternative proposal, which was all land must be expropriated without compensation, was itself a blunt instrument which could never actually have the nuance that is necessary. So take another category outside of the District 6, take another category, the people of Tolobeni. At the moment, the government and the mining company from Australia are interested in mining titanium. But the land is occupied by African people who have occupied it for thousands of years. They want to take the land. Under the law, they are entitled to expropriate the land. But the question is, should they pay those black people the market-related compensation, or should they pay them no compensation? Now, on the amendment that was being introduced, those people would be denied compensation whatsoever, because all expropriation would be without compensation. And yet, the way to achieve justice is to recognize the differing historical contexts of different people in South Africa. So in those circumstances, I would say there should even be above market value compensation, so that justice is always a graduating standard. It's flexible standard. It attaches value to your own historical position in the country and your own contemporary position, for that matter. One of the reasons why I've argued against this amendment is actually that it's a blunt instrument.
What you're saying is just so obvious. It's bizarre that it doesn't have that kind of nuance in a country like ours.
Yes, of course. The only reason why it doesn't become obvious is politics. That's the only explanation. Because if one actually tries to understand how the very idea of expropriation without compensation began, you go back to 2017 at the Newzroom Conference, and you look at the highly contested political climate of that conference and the sort of compromises that had to be made in the course of an election. So if you take out the politics, because often decisions that are made in the realm of politics are irrational decisions, in the sense of, not irrational in the sense of illegal, but in the sense of defeating logic, but they are perfectly compatible with the logic of politics. So that's really the problem. It's that we've packed the issue of land from the question of justice and we've placed it firmly in the realm of politics. Hopefully now that this misguided amendment has been defeated, we can go back to land as a question of justice.
Yeah, absolutely. I wonder if I can ask you to weigh in on a completely or somewhat separate issue that happened in the Constitutional Court yesterday. The decision in the Constitutional Court insofar as the residents of the Winnie Mandela informal settlement in Ekurhuleni, Advocate Ngcukaitobi. Have you been tracking that case? The decision yesterday by the Court to actually deny compensation. Can you take us through that? Because I've been reading through the summarized version of the decision in the Court, and some of what Justice Chris Jafta says is kind of surprising to me. He says the mere existence of a right under the Constitution did not give rise to a positive obligation on the state to provide housing on demand. Can you give us just sort of a blanket comment on that decision in the Court?
Yes, I think there are two things that I read the judgment briefly yesterday. There are two things that need to be said about it. The first one is you look at what case was pleaded in the High Court. So it's a technical explanation. So often there's a rule that says if you're going to go to the Constitutional Court on a demand or on a cause of action, that case should have been fully ventilated in the High Court before. So you cannot go to the Constitutional Court and ask for damages if you did not ask for those damages in the High Court. So that's just a technical question of what case was pleaded. And then the second question is, what is the content of the right under Section 26, which is the access to housing right? There is an old case called Grootboom. Many people are familiar with that case, which defined the scope of the right, which found that there is no, in a sense, right of housing on demand. You cannot go to the state and say, I want a house. What the right means, because it uses several words that are quite carefully chosen. One is progressive realization. The other is subject to available resources. And the third one is access to housing, as opposed to you have a right to a house. So what that has been interpreted to mean, I mean, there are people who are critical of that approach. What that has been interpreted to mean is When you are asking for the implementation of a right in Section 26 or 27, which is the core of the socio-economic rights, what you can demand from a court is that the state must put together a program that will ensure availability of housing to people who need it. But in the meantime, what you can ask for immediately realizable is an emergency accommodation. If you are losing the house and you are likely to be homeless, you can ask for temporary emergency accommodation immediately. So those are the technical nuances of the judgment. I mean, there is a large question as to whether, in fact, the Constitution should not be interpreted in the context of South Africa as imposing precisely that, a right to a house on demand. But other people will say there are other obligations imposed on the state. There are other demands. Other people want water. Other people want healthcare services. Other people want education. So why should the entire budget of the state be dedicated to housing when there are so many pressing demands?
Yeah. Very interesting indeed. And in fact, we're in conversation with the Socio-Economic Research Institute, who actually represented those 130 residents there. Also quite a close call judgment in the Con Court, which is interesting to note. The judges, 5 judges to 4, ruling against the awarding of constitutional damages. Advocate Ngcukaitobi, let me thank you for your time this morning, giving us a chance to pick your brain on all things land-related.